everyone. Welcome to episode 62 of the Immigration Lawyers Podcast. Thank you for tuning in again and listening to the program. I was hoping to have got this episode out last week or before that, but I filed an L1 case, which I think was a perfect L1 case, and we got this really stressful RFE. And the reason why it was stressful was because that there wasn't anything specific that they found wrong with it. They just generally said they don't accept it without specifying what the problems were, which made the response harder because we had submitted an extraordinary amount of documentation to back things up. So it's hard to pinpoint what the problem was to then try to explain it. And so we have to go back and explain everything all over again, trying to figure out what the problem is that they need a response for. And that took about 12 to 15 hours to do, a last second notice. And I want to do it quick because the time the client has in the US is limited, so we have to do it at a specific time. So that was like a really annoying thing that popped up, and it didn't allow me to do the podcast sooner. But I'm glad we're able to get in this one today as it is. I want to thank a couple of listeners, Guive, G-U-I-V-E, thanks for listening, Robert G, Dylan W, and Justin for reaching out, and everybody who listens to the podcast, even though it's less than it's once a month now probably, or maybe twice a month if I hopefully, instead of a weekly, you're still listening and emailing me. Thanks for everyone who's doing that. So without further ado, let's get it started. Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. Today is going to go in the direction that I've planned on doing it, which is really talking about more technical stuff with regards to immigration law. So again, if you're not a practitioner, feel free to listen, especially the first stuff, but it could get boring really quick. One quick note is that Department of State has updated its website, so it's changing things. If you go to Department of State, you'll see it looks differently. This has caused some glitches. Sometimes when you're trying to look at the visa bulletin, it doesn't come up. You have to do a search of the website that's better. Even the Google links that come for the visa bulletin sometimes don't work. But I think they're fixing it up and it should be done. And hopefully the information will be much easier to access. But generally, Department of State does a pretty good job explaining the civil procedure, consular processing process, visa reciprocity charge, visa bulletins. They're all pretty straightforward and well, so I'm glad that part of the system works well. On the other end, USCIS has the online system where you can put your case number in there and it sends you notifications. In the last week, I've realized that the system's not working. Getting cases approved, I'm not getting notification of the green card being issued. All sorts of different notifications aren't happening on that system. So it's so hit and miss. I have a I-131 reentry permit case, and no matter how many times I put the case number in the system, it says it's not found, even though we've got receipts and biometric appointments. So that's kind of annoying because I always want to keep an eye out on what's processing with USCIS to make sure I know as soon as possible if something's happening or not, and that's just not working. So there's a lot of stuff I want to talk about, almost 4 pages of stuff. A lot of it's going to be actually AEO decisions, and it's interesting that popped up. But it's, as usual, going to be in some random order, but I just wrote it down. The first thing that's here is there's a big op-ed in the Wall Street Journal by a professor in Las Vegas. It definitely, access the article and read it for yourself what you think, but as an immigration attorney, it came off as offensive as someone who's not an immigration attorney, maybe does some clinical work here and there, just bashing the system as a whole. Now, a lot of the focus article was on asylum and removal. These are case areas I don't focus on, and frankly, I've seen some terrible lawyering in those areas, and I've talked to immigration judges before too that they're just frustrated about the caliber of attorneys that come there. And that is a situation, but the way this article is written, it just puts it out as immigration lawyers are scumbags and losers. And this comes off the heels of the Justice Department head, the old senator guy. He just bashing immigration lawyers for essentially saying immigration lawyers are frauds too. So back to back, it was really inappropriate, especially for someone who doesn't practice immigration law, to just get into it like that. His solution was that we need to create a system where immigration lawyer wins and losses have to be put on some sort of chart, like it's like a basketball team or something like that, and so people can know what the win rate and percentage of this lawyer is. Now, again, this is why I see these guys in practice immigration law, because that's win and losses are completely out of our hands. You could be the best lawyer that's ever existed and take on cases that are difficult, or have immigration judges that just deny everything. And so it's putting a number on someone's craft that they have no control over, because it's more about third-party decision making. Now, I like the fact that there's reviews online, and people could, if the attorney's not good, write that online, and it's pretty representative, and that could come up. So that's somewhere people look. But this idea is so cockamamie that this guy came out that it destroys the rest of his arguments as well, and it's just very inconsiderate. It shows he doesn't know what he's talking about. Now, the school he works for is a good school, Las Vegas. The law school over there has other immigration professors that are great. They just got a big donation, I think like $250,000, so they could help immigrant youth, young child immigrants, and their needs. And so the school is good, but this one professor, I mean, he really needs to think before he writes this stuff. It wasn't very professional and thought out. It just ruined his own arguments the way he presented it. And I made a mention in one list service for professors. I was like kind of aggressive. So, but overall, you got to think this out better, because it doesn't help anybody by bashing the whole practice. There is a need to clean up the game, and that's just one of the things I've always been thinking about, and I want to put into gear for 2018, because the reality is there was another case, I think in like Indianapolis, where this guy filed 250 fake U visas, signing off for the police parts and all that kind of stuff, and they busted him. But like, the state bars are supposed to be policing on this stuff. I mean, it ruins all our reputations when we have these bad apples and nothing's happening to them. And I see it enough where people call me at least once a month where they say, oh, I gave this attorney the money, they disappeared, they didn't file anything, they filed the wrong thing, they didn't respond in time for an RFE, or all this kind of stuff. And it's like, well, call the bar. And most of the time they won't. But the ones that did said the bar didn't do anything and they just let it go. And so that's a big problem. There has to be some repercussions for these kind of activities and these kind of bad behavior, or else nothing's going to happen. And because like I could get a lot of cases if I promise people the world and tell them everything's going to happen. I'd be filthy rich right now if I just sold my clients bogus things just to close the deal and get the money, and then having no repercussions. But that's not the proper system, and it really ruins our reputation. So one thing we could do is create bar organizations that do this policing on their own. It's an idea I've had for years now, to create some sort of immigration bar that only accepts people that have good reputation, certain amounts of wins and experience, and client reviews in a certain way before they come in, and they can have that badge on their card and on their website to show that they've been vetted in a certain way. Because the California bar exam, for example, what does it really do? So you took a test where you memorized a bunch of stuff and put it down. It does show somewhat of intelligence, but is that really law, memorizing a bunch of law and then regurgitating it out really quickly on a piece of paper, and then in a 3-day exam, now 2-day? These kind of systems don't make sense. They're old school kind of ways. There are better ways now to be able to decipher. But at the same time, the same people who call me complaining about their lawyer, I put their name into Google immediately, and then Yelp comes, they have like 15 bad reviews, and I say, listen, I'm looking at this person, this is a terrible person. What made you think you could go to this person? And it's like, well, it's the first person they talked to and it's there. Sorry, you might hear the trash company moving some trash outside. There's bad timing on that. But these are the kind of things we deal with in our practice, and it should be all our goals, and it is for most immigration attorneys, to help keep the system proper and functioning properly to the best interest of both the immigrants and the United States. We live here, we're Americans, and we don't want the system to be abused, because all that does is it causes people to mistrust every asylum case when there's some asylum abuse. So we got to do everything you can and to help clean up the system, and not let third parties get involved that aren't aware of what's really happening, or who have other hidden agendas. On another agency front, CBP issued a very interesting letter from the Office of Inspector General. And what this was about is during President Trump's run, there was a Twitter account that was called Alt USCIS or something like that, and they would just call it as it is when it comes to immigration stuff and give their opinion. CBP used this summons power to find out who the person behind that account was, requesting it from Twitter. And this caused some court work and stuff, and eventually it seems the Inspector General said this was not appropriate behavior, it was abuse of the summons power. The summons power is directly related to the needs CBP has as part of executing its duties, but finding out who's behind a Twitter account where it could potentially have First Amendment freedom of speech consequences, trying to stifle speech, these don't fall within, it's far from that. And when they broke down all the summonses that they recorded, they saw like a good percentage of it were frivolous and shouldn't have been done. So at least this watchdog group highlighted that this is the reality, and it hasn't gotten much news, but it's a terrible thing to abuse that kind of power. But we'll see if they're able to do anything to fix that and change the people on top. This is gonna be hard to do, but I'm glad at the very least they identified that this problem exists and acknowledged it, and that's a very important part. Next, the startup visa rule that President Obama was putting into place when he left, there was a delay period before it was about to be instated and brought into place. President Trump came in, put a hold on that, and it was the process of getting rid of it. However, lawsuits happened, and a court now said that because there is no public period for talking about the withdrawal or stopping of this program, the administration did it wrong. So now the startup visa rule is back into play in a certain way. I'm not sure exactly how that's going to go, but potentially it's there. I think long term, this is not going to happen under this administration. They're going to find a way to shut it down. So I'd be hesitant to tell people or get money from clients or hold contracts that's going to be using this. I have had clients come to me where they had their plans of doing this, and now that's derailed. Now they're coming for a backup plan. So one thing I would say, don't rely on these programs until you see they actually happen. The same thing was with deferred action for parents of Americans or something like that. DAPA, that was there. A lot of lawyers were getting money up front in preparation to submit this the second they could. All my clients said, listen, let's see what happens first. Let's see other people file it and then do it, because you never know. So you don't want to take clients' money and then not be able to file it and then have to give it back, or they have an issue because you've done the work, so you deserve the money, but at the same time the case is not possible. And so what happens? So in those kind of cases, I just say no getting money up front. Wait for things to actually go to a place where they can actually happen. There's examples before doing it. I think the same thing happened actually with the waiver situation, the travel ban coming into place, which we'll talk about more. But I mean, people are calling me wanting to do a waiver. I said, listen, no one's ever done a waiver for the travel ban before. I'm not sure how it is, what kind of work it is. I'm not even sure this travel ban is still going to hold. So let's just wait to see what happens. But some lawyers, prepped the whole waiver is ready to go. And then, travel ban had the injunction, and the clients didn't need that. So they just spent money. They're going to be annoyed that they want their money back maybe. And it creates all that animosity. So it's just not a good way to go about it. There was another report by a website called Meduzo.io, Meduzo.io. So I don't know how legitimate this is, but they're saying Russian B1, B2 denials are up tremendously. But when you look at it, it says it's 1.25% rate. So that was kind of a weird thing. But when I did further research, that they were saying some interesting points. Tourist visa requests from Andorra, Liechtenstein, Monaco, and San Marino, they've had 0% denials. These have perfect 100% approval rates for tourist visas from these countries. Now, these countries had 100% denial rates. Western Sahara and Micronesia. The other top denial rate countries are Afghanistan, Iraq, Syria, and Armenia. So that's something to think about when you're from these countries. And it's interesting, there's a 100% rate of denial and a 0% rate of denial on these specific countries. So it's something to think about. Also, Axios is reporting that the number of student visa requests has dropped by 3.3%. Follow loan was 6.9% drop in foreign enrollment. So probably the travel ban stuff and just the overall perception of the United States internationally has taken a hit. I think foreign students are really good because they bring an extra flavor to schooling. They bring a lot of revenue to local colleges. So essentially, foreigners are investing in the education infrastructure of the U.S. by paying the higher foreign student tuition rate. So it's an excellent way to boost our own people, and at the same time, bring in smart people, wealthy people, or hardworking people. It's a great program, but student visas are on the attack. OPT is on the attack, and so these are the things that are going to happen. Moving on, the AAO adopted a very good case. Relatively very good. It's called Matter of VSG Incorporated. It's Matter of G-Inc. And it specifies the functional manager, at least in more detail, what it actually is. It's always been vague, and I've always been hesitant to even use it because of the vagueness of the functional manager component of an L1 or an EB1A green card. And so now they defined it. It's very interesting. In the decision, the AAO doesn't know what the definition is. So they say go back and they actually look in the dictionary to look up the words functional and manager and essential and all this kind of stuff. And it's kind of just shows how ludicrous the system is, L1, and how much it opens the way for unfrivolous denials when there's no definition. The statute says a word that has no definition, and then we spend decades trying to figure out what that definition is, and eventually the superior authority goes to a dictionary to find what a legal definition for an immigration case is. It kind of puts the whole system as kind of a joke when you see it's like that. It had to go this long for them to think about the functional manager definition being too vague. And so it's something I haven't used, but a recent case I did, it was an executive. I also said, listen, based on this definition, they're also a functional manager. You could be both of it. So we'll see how that one works out. I should be getting the decision in a week or so. But there's another case that came out. This is really good for portability cases, matter of VSG Inc. It says affected parties in a revocation can include the I-140-/I-485 beneficiary. So, you know, for employment-based green cards, you have the petitioning company that does it. Normally, they have the rights to do stuff, and the beneficiary is just like, you know, chop suey in the corner. But for these kind of cases, when there's been portability that's been executed with an approved I-140, the beneficiary can be involved in revocation proceedings. It has some more rights. Essentially, the foreign immigrant has a little bit more rights in employment-based cases than they did before. So that's an interesting thing. It's really good. A terrible thing that really highlighted an important factor you got to notice is the post office was shipping deferred action cases before the deadline that was set by President Trump. Apparently, maybe thousands even applications were submitted, got to Chicago, and the post office just spending a week turning in circles. The deadline passes, then they deliver. Now, for some reason, I was under the impression that the mail date of the postage envelope was the receive date that USCIS would accept and it would be okay. That's completely wrong. The second USCIS gets an accepted case, that's what works, and that's what they base the deadline on. So be very careful. Like one thing I do now is I send everything priority express mail, which is next day delivery, because like I usually try to use the post office for traditional stuff. The 2-day stuff, sometimes when I do priority mail 2-day, there's tracking with it, but sometimes it takes them 10 days, 2 weeks to deliver, and that's horrible. So I started doing Priority Express, but even those, I mean, I have these right now. Where is it right now, the receipts? I have all these cases where I got to get my money back because in December, the post office is not delivering Priority Express in 1 day like they're supposed to. So they're really unreliable using US Post when you have these hardcore deadlines. You got to use these private services, UPS, FedEx. They're more reliable right now than USPS for delivering urgent kind of stuff. And now, if it's not that urgent and you want to file regularly with Priority Express, there's at least in December, there's a good chance you get your money back to their late delivery. But getting the money back from the post office takes so much time, it makes it not worth it. But that's just something to be mindful of. Be careful when you send it, and be careful using US Post Office for these really important deadlines. Now, there's been a lot of reports in the newspapers too, finally, about naturalization cases taking so long. I have clients that are super frustrated with me saying, you told us it's going to be this long. And I said, listen, I thought so too, but the reality is that it's taking much longer. Now, it had gone up to 8 months processing time. It's come back down to 6 months right now. I'm getting cases to their interview in 6 months. You know, after the interview, getting an O ceremony takes forever too, so that's a variable. But in this report, they're saying LA County cases are taking 10 months. That's more, actually I have 10 months cases too, so it's kind of all over the place, but these delays are real, and they're probably just going to be increasing because I just keep getting more and more people calling me about citizenship because they've had a green card for a long time, they didn't care, but the new administration is forcing them out of fear to actually apply for citizenship. So yeah, that's something that happened. Let the client know from the beginning that these times you give them are estimates and they could change. Set the expectations as soon as possible. And I thought I did that, and I tried to send an email too, but one of them I didn't. I said it orally but on the email about timelines, and I'm like, okay, in the follow-up email I do for consultations, write it out. These are estimates, but they could change drastically, case-by-case basis, so you don't have that phone call later and them freaking out, or something you have no control over and you can't do. So that's that. Now the State Department. So moving on. State Department's been having a lot of problems. I think the internal State Department people are very frustrated with the direction things are going, both under the President and both under the Secretary of State. To add insult to injury, the State Department is pushing a buyout program to buy off staff so they could retire. They're cutting down foreign service officers dramatically. And I've read articles on both sides. Some saying these foreign service officers are just like, you know, all this money and having this lifestyle, overseas in Europe and all this kind of stuff. I doubt that's really the case. But at the other end, from what I deal with and what we deal with consular processing, we know how much overwhelmed they are and staffing is low for them to handle all these cases. So this cut down in State Department employees is very bad, very negative, and frankly on a geopolitical level, we're increasing the troops, but they're decreasing the diplomacy. So it shows what direction we're going as a country when we're getting rid of the diplomats and increasing the warriors. Both are necessary, but that change in ratio is something to be mindful of what direction we're going to go. Another point, Form I-693 has been updated. This is the medical certificate for adjustment applications in the U.S. I had one client that came in and he had his medical from a while ago, and I said, go get a new one because they're not going to accept this after, I think, January 3rd or something's the deadline. And he's like, are you sure? Are you sure? So I went and read the edition updated language, and it said that if the person has, you have to use the new version of the form if the signature on the form by the doctor was on or after January 2nd or 3rd, whatever that cutoff date was. And in this case, the doctor signed this guy's older, previous version of the form like 3 months ago. So I'm like, wait a minute, that means as long as the doctor's signature is before that date should be okay. So I guess we could use that. Now I told him try to get a new one because you don't know which USCIS office is going to review this and which way they're going to go. But that was interesting. I thought normally as soon as a new form comes in, that's a hard deadline and you just can't use the previous ones. But in this case, the language was written about the signature date when that happened. Another interesting thing is the State Department has said that they're going to take back passports from people who are convicted child sex offenders, and they're going to issue new passports for international travel that references the fact that they have these specific crimes, which is going to be kind of crazy because when these people travel overseas, especially in certain countries, it can be a big problem. It's something that's going to follow them. It's their identification overseas. The one aspect, this is a horrible crime and these people should be in jail and really not getting out of jail. But the reality is a lot of people do get out of jail. Sometimes they have minor charges. It might be like a 19-year-old dated a 16-year-old or 17-year-old. These problems happen. And having them not be able to run away from these crimes or be habilitated in some way, rehabilitated, could be a problem and make him more of a menace to society because of the fact that they lose another set of freedoms on a continuous level and wear a scarlet letter, they carry that at least with them. So it's a little bit of tornness of like how strict do you want to be on this population. Potentially it can make things really hard. For example, I think California, they passed one law about like 10 years ago that said if you're a convicted child sex offender, you can't live within so many feet of a school or a park and this kind of stuff. And it made it so that like sex offenders all had to go in just certain communities because that would fit outside of having to have a school or a park because there's schools and parks everywhere. And so also you made communities of all people who are child molesters and stuff like that. And you have people already living there, supreme danger. And also these people then can't really find a job that's close to a good area, all this kind of stuff. So then they go not having money. And so you have a person who's psychologically distressed that does these kind of crime. They're feeling the pressure of not having money or friends or connections. All that mixes to make maybe potentially a worse result. I don't know. I don't have the facts on or statistics. But that potential exists of making more problems. And at the same time, you have people that are child sex offenders, all of a sudden all knowing where each other live, all living next to each other. It can be a big problem. I was watching this TV show. It's a comedy thing called Fresh Off the Boat. If you're an immigration lawyer, you should definitely watch it. They have one. This is Chinese family that have 3 children. The 2 younger children are like really good kids. The older one's like trying to be a bad boy, but he's not. So he does something where he has to go to detention. And his friends are all goody two-shoes where he eats in the cafeteria and he's getting frustrated with them because they're all goody two-shoes. He goes to detention, meets like 3 of the bad kids, and then he starts hanging out with them and he ends up like stealing stuff and ditching school. And I was like, wow, and the same thing with the prisons. Do we want to take people that have issues and put them all next to each other so they could like get worse and be friends with people like that and make it sound like okay that behavior by putting them in a group of that? Is detention or prison or putting everyone in one community that's like that really a good idea? Maybe it's better to take them away from individuals like themselves and be around better individuals to be affected by that. That's like a really opposite way of looking at these things. Just popped in my head reviewing that. I don't know if it's going to work or not, if it's like really makes sense or not, but it was just interesting to see I mean, this catchphrase is famous of people going to jail for petty things and coming out professionals because of what they learned, all the pressure, and the the scarlet letter of having been in prison. So sometimes you think, are these measures of like putting debilitating things on people on a continuous basis and having them congregate together as opposed to freer society, is that helpful for what you're trying to solve, or does it hurt more? That's something social scientists really have to think about before doing these kind of things, or pulling it back if we're already enforcing these kind of laws. And finally, with regards to these general news stuff, the travel ban is in full effect as of Monday, I don't know, late November, which means the exception that they had for relatives, immediate relatives of sort, to be able to undermine the travel ban is gone. Right now it's a full travel ban. Now the waivers and exceptions do exist, but I'm not sure how the waiver is going to play out and how strict they are. For example, I have marriage cases from Iran or fiancé cases, and I say, listen, my advice is the USCIS portion of I-130 is going to take 6 to 8 months right now. So just start that, get out of the way. Depending on how the travel ban works, we can always push the can down the road for consular processing until we figure it out. And on the other hand, even if you do consular processing, the hardship standard that's for a waiver is not extreme hardship like a 601 waiver. It's just regular hardship. So if a spouse is separated from their U.S. spouse, that's hardship in and of itself, and that should qualify. I mean, I think so, but will an officer think that? I don't know. We have to see examples, see how tough they're going to be on this. But I think that should apply. Being separated from your spouse is pretty horrible, or your kids, or all this kind of stuff. So it's definitely worth going forward and just getting yourself in line. And who knows, these things have changed constantly. So in 8 months from now, when that would happen, or if you're an LPR, a green card holder applying for your spouse, there's a visa bulletin wait of at least 2 years. So get the process started now, get your priority date, and then just wait it out, see what happens. That seems like the way to go. That's what that's what I'm telling clients. I had with regards to the L1 case I was talking about earlier in the intro that delayed it, I was thinking, like, how do I respond to this officer? Because there are a few, it's very unfair. We provided probably the strongest L1 case ever submitted. The guy had super legit. This was an easy open and shut case to me, and it got this RFE that was just general, asking for stuff we've already saw, and not really specifically asking, generally asking for the definitions of functional manager and executive that they always do. And so I went to the listserv and say, how do people deal with this? How do I escalate it? Because I did premium processing. I could call them and maybe go to a supervisor or fax them to try to push the issue. There's also scopes. There's a group that reviews RFEs just if there's a problem. But all these would either antagonize them or, on the other hand, delay things. And I need to get this case approved as soon as possible. So I ended up just responding to the RFE and saying, listen, you didn't ask for any specifics. I don't know what to do. Here's the old stuff. Again, we provided, highlighted, exactly answering what you're asking for, as well as a couple of new stuff that hopefully would overcome it. I don't know. When you have no control or you don't know what you're supposed to answer, it makes it really stressful. You're like, I don't understand what you want from me. I already gave these exact documents you're asking for. And in some of the main parts, they actually acknowledge receiving those documents. So I'm like, did you acknowledge receiving the document? Did you actually read it? Because it answers all the questions you're asking. That was a really bizarre, stressful thing. I was hoping not to have to deal with. I got a call that was very interesting, and this is very important because it pops up and could lead to malpractice, but immigration lawyers got to be mindful of this. When it comes to marriage cases for cousins, in California, it doesn't matter. California is open to cousin marriages, everything's good. So I deal with that and I never thought about it, but it doesn't apply in a lot of other states. For example, in Nevada, marriage between cousins is a crime no matter what. They don't recognize it. Now, I'm not sure what the extent of not recognizing it is, but for I-130 purposes or fiance visa purposes, you can't say my fiance is going to come from a foreign country. We're going to get married in the U.S. and Nevada because they're saying it's invalid. You're a resident of Nevada, so you're not allowed to. It doesn't work out. So how to deal with that nuance in particular is very interesting. The guy that called me, his lawyer had done the I-130, got approved, and now he said he can't do consular processing because they can't do marriage in Nevada or something like that. And so he was thinking about, changing residences to California temporarily just for that purpose. I'm like, well, that may work, but we got to get into it and study it. And I hadn't heard back from the guy. But it's something very important to be mindful of. I think a lot of states, either, Nevada is one of the more extreme that they don't accept it at all. I think like Washington State doesn't allow cousin marriages, but like you can move there if your cousin marriage is recognized, and that kind of stuff. And I think a couple of states in the South don't either. So be very mindful. Like always ask, because I've had cases. Luckily, everything worked out. where like I asked them how they met, they tell me all these stories, then like 3 months later, like, oh, by the way, we're cousins. I'm like, well, you got to tell me that at the beginning. Luckily, there were cases where it didn't affect things. It was in California, it was okay. But be very cautious of cousin marriages because it's still prevalent overseas for people to get married when they are close relatives. Moving on to discussing actually content processing, I finally was able to deal with the new or the pilot programs the National Visa Center has for document collection. Primarily, I saw this coming in through Brazil. So I have a Brazilian parents of a U.S. citizen case, and so the pilot program they have with Rio de Janeiro allows you to submit the DS-260, but also upload the FAA support documents and the civil documents directly there. There are some glitches, like when I uploaded W-2s, and they're like, you need to upload W-2s. And I was like, well, like, look at the documents of W-2s. So, but the response to that was 24 hours. And so once I uploaded everything, within 48 hours, they had accepted everything that was done. So that's a big step forward as opposed to the old NVC mailing system. Now, this is a pilot program, so they probably have people with spare time to do this. And the whole system turns over to this electronic program. Probably the same delays will come in. But it's interesting because you could upload stuff and put it there. They have like a 2 megabyte per document thing, so you got a maximum, so you got to be able to manipulate document sizes and scanned images so they become smaller sizes. But it worked out pretty well. I was actually really happy with that at the end of it. At first it was just some growing pains of trying to frankly, like some documents I sent were correct and they found a problem with them, but it was so fast to correct that made it okay. Now we'll see how long it takes to get the interview afterwards, but I did that with Rio, so it was good. Now Baghdad, Iraq is supposed to be a special pilot program where they're instituting this. Their system is different, so I'm doing an Iraqi case right now. Still waiting on information from the client to submit the DS-260. Interestingly, the Brazilian case, for the mother, they didn't ask for the addresses and work history, the most recent stuff. Actually, they asked for addresses, but they didn't ask about work history. But for the dad, they did ask for work history. In the Iraqi case I'm doing, they did more than just ask for 10 years work history, which is normal. They asked for all work history, so that was kind of weird. But I'm still finishing DS-260, but that's supposed to be another system where I'm supposed to upload things. But it's not designed the way Rio is, where you have different places you could click to upload like civil docs and stuff. Right now, I could just do a DS-260. I'm guessing once that's done, some other options open up, or I can email them or something like that. So that's just an interesting thing that's happening. There's some notes here I've taken about shared offices for TMs and stuff, and joint sponsor stuff for I-64s that not as fun now when I talked about it last, so I'll skip those. There was an article I read, I think it was the LA Times. It was really interesting. This woman wrote about her ex-husband, who was a top Silicon Valley lawyer, and he died of a drug overdose all of a sudden. And she went and looked at his phone and saw the last call he had was actually a consultation session with a client, all this kind of stuff. And being a top intellectual property lawyer in dealing with the tech world, all that money and all that pressure and fame and all that kind of stuff, the guy had become a full-blown drug addict while handling a practice profitably and successfully. And so that just was something interesting I wanted to bring up, of the difficulties of being a lawyer and the stress that comes in with all these cases just being flooding around you. And to always be careful not to fall into a place where you definitely need to have, overspend yourself, where you need to take on cases extra, or just taking on cases because you're making a lot of money. It's very easy to feel distressed, and to a certain point then need to compensate for that with drugs, sex, alcohol, and all this kind of stuff, which is an epidemic in our field. So to be very cautious and be careful of that. It's a fascinating story if you could read it, to see such a successful top law school kind of person, top law firm, just their life being torn apart because of drug abuse, because it's frankly stress from the work probably, but the guy might have personal problems as well. Okay, so I'm trying to start moving into a lot of decisions recently, mostly for business cases, almost all for business cases. So if you're not into business immigration, it's going to be less fun listening to this. But there was a couple of EB-1 cases that were denied by the AAO. They're interesting jobs. One was an interior designer, which isn't as far off, but for extraordinary ability in the field of interior design, that's a little bit different. But there's another one called remote sensing researcher. I think these are the people who do paranormal activity and stuff. They filed for an EB-1. It was denied, but it's always interesting to see these job titles that are put in for EB-1. Sometimes you see ridiculous stuff for EB-1, like just a teacher in a general school, and see it as a natural interest waiver too. I mean, high school teacher is a very important job, but to say national interest waiver, EB-1 just for teaching a high school job, to me it reeks of a lawyer just lying to their client to make money, and to have the courage to file an AAO appeal of something like that is just ridiculous. With regards to employment-based cases, the issue, and I've talked about this before, of the interview system is coming up, and it's so stressful because, you know, I have clients Connecticut and Florida, this kind of stuff, and I want to go to the interview with them. Now, word is that the interviews haven't been too bad. And people have been just going there asking basic questions, and the officer's been really simple and stuff. So I haven't heard any bad things come about it, but it's inevitable. They more get comfortable with the situation, they learn about I-140s, and they want to ask questions about that kind of stuff. So that's bad. One thing to take away is just always take a new G28 with you for those kind of EB employment-based cases. Even though if you have a G20 on record, you never know, the officer just might want a new one. You don't want to be caught without it. It could be really bad. One area that had to pop up for me is portability. I had a case that, of my own cases, my clients that had this. Interestingly, there are a lot of AEO decision on this, so it's very important. Specifically, I had a L1 to EB1C portability issue that came up. One thing to be mindful of is there's the dual interest, conflicts of interest. Make sure to deal with that properly in your contract because it could be a mess. But interestingly, if you're doing an EB1C, which is an intercompany transfer kind of multinational manager executive green card, where a foreign employee is coming from like a foreign branch or subsidiary or whatever it is to the U.S. to work, once the I-140 is filed and the I-485 is filed, if 180 days passes, which allows the portability window to open up for switching jobs, for L1 / the EB1C portion, you don't have to work for a job that's like a subsidiary or whatever of the other company. You have any other job, it just has to be similar or comparable to the job that you're getting the green card for. So it's really interesting that after 180 days, that L1 / E1C lock that company has on you goes away. And so that's something very important to think about and to know when advising clients on this stuff. One important case that came out in the AEO that's very important for practitioners to know is that in this case, the person had tried to do job portability, didn't happen because they hadn't filed the I-485 early enough for the 180 days to take place. Now they had filed the I-140, waited, and then filed the I-485. It had been 180 days more from the I-140, but not from the adjustment of status. And the beneficiary here, or the people filing the appeal, said that the counsel didn't tell us that the 180 rule for portability exists, so I didn't file the I-485 sooner, where if I had, I would have been able to take part of, portability. And the AEO said, yeah, I'm going to send this for review by the director because of this and another issue. And so all of a sudden I said, wait a minute, like, so what's going to happen? Because they didn't tell it. Is that considered malpractice? Is that going to have some sort of Lozada claim that can help solve this stuff for not telling them that? The attorney should have told them. But the employer is usually the person paying, and so attorneys really tell them all the information a lot of times. You got to deal with the beneficiary as a client and tell them about portability 180 days, even if the employer doesn't really want you telling the beneficiary, the immigrant, that yeah, you have this option to bail after 180 days and to file that. Now, one thing about filing for the I-485, especially after an I-140, is, especially when you're doing something like the EB1C that doesn't have premium processing, you can file the I-140, which is going to be expensive. I mean, the filing fee itself isn't too much, but the legal fees are high. But then if you come to an adjustment of status, right now it's $12.25 per person. So if you have a nuclear family of like 4 parents and 2 children, that's like $4,000, almost $5,000 just in government filing fees, not including the attorney fees. And then add to that later the interview fee that comes up. So do you really want to file the I-140 with the adjustment of status and have them pay all these fees? Where if the I-140 isn't approved, you just wasted all the adjustment of status fees? My policy has always been telling them that you could do this, but hold off because let's see if the I-140 is approved. I think it's going to be approved. I haven't had a denial before, but I don't want you to put all that money for adjustment of status and not have it happen. That's going to suck. But I guess the policy now is tell them that they could file it sooner and just do it, because not only for portability issues, but also because of the delays that are in the system right now for employment-based cases. Potentially filing a concurrent case when possible with the I-140 could, make things work faster and smoother. And I had a previous podcast that talked about this. And you can file the I-485J with it and all that kind of stuff. Just get it all done at once while everything is smooth, and then hopefully 180 days passes, so it gives more leeway for people to do whatever they want to do. But that's something to be mindful of, being held at fault for not informing clients of the 180-day rule for portability and being accused of ineffective counsel. So that was something that wasn't good. There's another case, and you know, there's a lot of bad appeals cases, but there's some ones that like the director is really not being friendly. There's a matter of H.C.W-A-C blah blah LLC. I hate the initials and the naming they have on these cases. But the director denied the case for ability to pay, saying there wasn't enough income for the company and they didn't have enough assets to cover things. Well, the way the director was reading it, they took the equity the company had and subtracted their assets, and they said there's no money left. And the AO was like, wait a minute, that doesn't make any sense. You don't subtract equity from assets. That doesn't make sense at all. So they reopened the case and approved it because they had the assets, millions, to cover the ability to pay requirement for the I-140. There's another case, a matter of H-K-B-R EB1A case, that was denied, and it's a quick thing. They had the 3 criteria for a sensor engineer and system architect, but the Kazarian analysis failed. They matched the criteria, but the officer said Kazarian doesn't work, and on AAO they also agreed. So even if, and I get people calling me all the time, oh, I have the 3 criteria. I said, like, listen, first of all, you don't understand what the criteria mean. Just what's written on the EB1 website for our USCIS doesn't fully show how strict they are on these criteria. Second of all, the Kazarian analysis is real, and that can really shoot you down. You just can't be filing cases willy-nilly without thinking about that. The Kazarian decision, for those who don't handle EB1 cases that often, is a decision that was made where, I think 2012, when they said that even if someone matches the 3 EB1A criteria, there's a secondary analysis the officer was going to do to say the totality of the circumstances, does this feel like EB1A? It's not as strict to just check the boxes, the matching criteria. There's a totality that they're going to look at and get a feeling like, does this person really have extraordinary ability or not? And that hits people really hard. And it's going to be really disappointing to know if you match the criteria but get that. There's another interesting case. There's one professor filed an EB1A, denied. They filed 7 motions on appeal, and the 7th one was denied again. So this person is not giving up. They're just keep going. So I mentioned perseverance is key, but I think after the 3rd or 4th time the appeal gets denied, you probably should stop wasting your filing fees. Another case, actually, this is very important, and it pops up every once in a while when you're doing L1 cases, which is how do you calculate the time a person on L1 has been working for the company abroad if they're traveling and visiting the U.S. Now, the rule is this, so short-term visits like on B1, B2s, right, coming and going, those don't break the continuous work period that's required for an L1, but that time is subtracted. So if, let's say, a person is coming and going, you not only have to look at a year, you have to do 365 days in total working abroad, not counting those. So it might go a year and a half, for example. So that's something very important to be mindful of, because some people working overseas do a lot of travel to the U.S. with short trips. But these are short-term B1, B2 trips. In the case that happened here, a person was working abroad, came here on F1, was here for a certain period of time, and then was filing for EB1. The F1 period caused the work abroad to get pushed out of the 3-year window, so that 1-year continuous presence was like 3.5 years before filing for the case. And they made an important discussion here, and I think they said this applies for EB1s, that L1s go with this as well, because there's so much overlap between 2 areas. It's that if someone's here on a non-immigrant visa, it's a work-based visa, like an H-1B, an L, or an E, the time in the U.S. could be subtracted and it'll look away, meaning they could get pushed back and look farther than the year period if the period in the U.S. blocked that time. And I hope I explained that well. But if you're doing like a student visa, or like an F1 or J1, J1 is a semi-work one, but an F1, I mean J1 too, because I think they're pretty specific, it's H1Ls and Es. But that F1 period pushes back the 3-year window, so you can't get back lost time in an F1 that you've been in the U.S. Whereas if you're on an H1B here, you couldn't go back. You can go back in time and get that time back. So it's a very important distinction to keep in mind, because it happens enough where you have L1 clients coming to where you have these kind of scenarios, especially if they own the company and stuff, that they're coming back and forth and traveling. I had one case where a guy was an employee. His wife had an H visa for the last like 5 years, so he was working in South America. Now he would be at his company for 2 weeks, then would come and be with his wife for 2 weeks. He was doing this for years, so like we're like, oh dude, like we had to get his flight records and add up all these days. It was a mess to coordinate it all, but we were able to, like, you know, show that the days were there, so that works. But it's just something to be mindful of. You can't just willy-nilly submit it. They're going to get you on that. It's an RFE. Some other quick notes that's always remember. if you get a denial decision, it's the requirement that USCIS fully explain the reason for the denial. So when I got that RFE on the L1, there's no explanation of what the RFE was about. It just restated the L1 rules, and that's very frustrating. But in matter of M-P, this is a BIA decision from 1994, and it really goes to 8 CFR section 103.3A1I. They have to fully explain. If they don't, that's immediate reopening of the case for the director to review it again, or at least spell out what the reason for the denial is. So always keep that in mind to expect that. There was another case where USCIS denied the business non-immigrant visa because they had gone to the applicant's website, and the website didn't mention for it was L1, the foreign subsidiary or the employees that the US company has, to really show the depth of the workers and managers and qualifying relationship. And they denied the case, after RFing and other stuff, they denied the case based on that. And appeal, AAO said that they should have given that derogatory information to the applicant, the petitioner, so that they could challenge that. They can't just find derogatory information on their own and deny it and not give them a chance to rebut it or explain it and stuff like that. So that's another thing. You think they do this all day and they would know the rules and wouldn't do this kind of crazy stuff, but there's always new officers or officers that just don't care, that'll just make up the rules or just not do the perfect job. And really, I've been blessed. One thing is, and I got this RFE that I was complaining about, it's between the business immigration lawyers, there's big talk of how frustrating the L1s are, so many RFEs. I almost never get RFEs on my L1s because I bulk up the initial petition so much that everyone would talk about his RFEs. I'm like, well, I know USCIS does kind of stuff, but I haven't seen it. But it happened to me too. So it's a really bad situation, and it just shows how difficult it is. Like, no matter how much the case is strong, these kind of things happen. So we have to be on battlefront mode, especially for business-based cases. L1s, H's, I mean, I don't do H's, but you all know the battlefront that is the H with these crazy RFEs that are coming. Lower and lower numbers of these cases get approved. Really good cases that aren't getting approved. It's going to be a challenge during this administration for these kind of cases. Even though they're wonderful cases, they really help the U.S. economy and the U.S. workforce, they have a really bad rap because of the propaganda that they get. So it's something that we be mindful of. Last note on these AEO decision, there was a site visit case where they visited a restaurant, husband and wife working there. The husband was on the L1, wife was the owner. They issued a notice of intent to revoke because there was only 2 people seeing the restaurant. AEO reopened it and said no, they have supervisors and employees. The wife was also an employee. She owned it, she was helping, and they're in the process of expanding the restaurant. It's okay. So if you get a notice of intent to revoke from these site visits, to me, when I was reading the facts of the case, being a restaurant L1, I'm never a fan of people doing retail kind of things unless they're going to do multiple locations really fast. But this one was made okay. The AEO approved it, so you could challenge these site visits. Always good to prepare the client, let them know what they're expecting, and have a session on that, which is time consuming. They're probably going to forget half the stuff you tell them, but have them be prepared for these site visits because it's only going to get worse the more this administration goes forward. So thank you so much for listening. We're in December right now. I think I'm recording this on December 8th. The holiday season is coming up. Some people are really busy right now. Some people are really dead in business, and it can be very frustrating. But at the end of the day, take advantage of this time kind of just to relax. After I filed this L1 RFE, I took 2-3 days just to calm down. I remember when I got the RFE, I was so angry and frustrated that for a day I couldn't do anything. Once I filed it, I was kind of in this zone for 2-3 days, just calming down from it because it was really frustrating writing that answer. But I have a bunch of cases coming up and clients saying they're going to bring me the case, they're going to bring me the documents for months, and they'll all bring it now. So it's going to be a busy December because of client delays. But take time off just to really relax and look back over the year, what kind of cases you did, how much money you made on certain types of cases, which advertises works, what's your state of mind and everything, what you're doing. That's one thing I've always really focused on, is how you're dealing with the stress with everything that's going on. You also have clients that are dealing with getting the short end of the stick and feeling the pressure of the administration, or even before, during Obama's time, deportation and stuff. And that sticks with you, unless you're like a psychopath or sociopath that can't internalize other people's emotions and have empathy. Having these kind of scenarios, even in my business cases, where a person's investing here, they're putting their life on the line, and all of a sudden, USCIS gives an RFE, it's a lot of pressure on these families because they have kids, they're trying to enroll their kids in school and just trying to live a good life in the US and be productive. And we absorb that kind of stuff, so be mindful of that. We're dealing with a lot of stress just because we're in lawyers wear suits or get paid higher dollar amounts. is not necessarily so. A lot of time when you look per hour what we make, it's not necessarily that much with the amount of stress and time we spend into it. But really focus first and foremost on yourself and then the people around you. Keep that healthy. The rest will fall into place. Don't overextend yourself financially or with work and everything like that. There's a lot of other stuff I could talk about, but I've been talking straight for a long time, so my throat's feeling it. And I have a consultation coming up, so I got to keep myself a little fresh. But all in all, I hope to have some more of these podcasts and some more information and programs coming in the new year. Thank you for everyone listening. I want to wish you all a happy holiday season. Feel free to email me with any questions, comments, or anything. My email is info@jqqlaw.com, info@jqqlaw.com. I answer my emails myself, so you'll get me, and I try to respond really fast. Thank you so much for listening to this episode of the Immigration Lawyers Podcast. It was a pleasure as always, and I hope to see you next time. Bye-bye.